Welcome back to the deep dive. Today we're getting into a really foundational piece of law, the Promotion of Equality and Prevention of Unfair Discrimination Act, Act 4 of 2000. People usually just call it PEPUDA, thankfully.
Yeah, thankfully. And it's more than just, rules and regulations. It's really the legal engine trying to make the Constitution's promise of equality a reality.
Right.
And what we're looking at here is the consolidated version. So it was signed way back in 2000, but parts came into effect later. And crucially, it was updated just recently, October 2024. So it's definitely still evolving.
Okay, so our goal here, for you listening, whether you're just trying to get a handle on your rights or maybe you're wading through law texts, is to unpack what this act really tries to do, what it forbids, and importantly, how it's actually enforced.
Exactly. The purpose sounds simple, but it's huge. It's meant to bring Section 9 of the Constitution, the Equality Clause, to life. Basically two main goals: stop unfair discrimination and harassment, and actively push for equality, trying to root out that discrimination that's still kind of baked into this system.
Okay, let's talk about that system. The historical background feels really important for understanding why this law is so, sweeping.
Oh, absolutely. If you read the preamble, it doesn't mince words. It says flat out that building a real democracy means getting rid of social and economic inequalities that are, and this is the key phrase, systemic in nature.
Systemic. So it's not just saying, okay, bad things happen. It's saying the law has to respond to the ongoing effects of colonialism, apartheid, patriarchy, stuff that's deeply embedded.
Precisely. It acknowledges these inequalities aren't just history. They're still shaping things now. And the whole act is grounded in constitutional values: dignity, equality, freedom, social justice. It even mentions fulfilling international obligations like conventions against racial and gender discrimination.
So it sets a really high standard. How does it make sure everyone actually has to follow it? What's the reach?
Well, Section 5 is very clear. The act binds the state government at all levels and all persons. And here's the kicker. If PEPUDA conflicts with any other law, except the Constitution itself, or a law specifically amending PEPUDA, then PEPUDA wins. It takes precedence.
It's the top dog on equality issues, then.
Pretty much. There's just that one main exception people sometimes get tripped up on regarding employment.
Right, the Employment Equity Act.
Exactly. PEPUDA doesn't generally apply to disputes covered specifically by the Employment Equity Act. So broadly speaking, if your issue is purely about, say, hiring, firing, promotion within a job that's usually EEA territory, but discrimination in accessing services, housing, education, public life, that's where PITA comes in.
Okay, that helps clarify the boundaries. Let's move to the core of it, what's actually prohibited. The big rule seems simple: no unfair discrimination by the state or anyone, but discrimination itself needs unpacking, right?
Yes, and the definition is deliberately broad. It covers any act or failure to act, any policy, rule, practice, anything that directly or indirectly puts burdens on someone or holds back benefits based on one of the prohibited grounds.
And that indirectly bit is crucial.
It's huge. It catches those seemingly neutral rules or policies that actually end up disadvantaging a particular group. Systemic stuff.
Okay, let's list some of those prohibited grounds. Section 1 lays them out. We've got the ones you'd expect: race, gender, sex, color, ethnic origin. But it goes much further: pregnancy, marital status, sexual orientation, age, disability, religion, conscience, belief, culture, language, birth, and importantly, HIV/AIDS status.
That list is pretty comprehensive, covering most of the common bases.
Yeah.
But then there's what I think is the real genius of the Act's paragraph, B, the catch.
Oh, yes, the safety net.
Exactly. It says discrimination is also prohibited on any other ground not listed if, and this is the test, if that discrimination, 1, causes or continues systemic disadvantage, 2, undermines human dignity, or 3, seriously messes with someone's equal enjoyment of rights in a way comparable to the listed grounds.
So if society comes up with some new, awful way to discriminate, the law can potentially already address it.
That's the idea. It makes the act flexible, adaptable. You don't necessarily need Parliament to amend it every time a new form of prejudice pops up. Think about potential issues around, say, genetic predisposition or maybe even caregiver status down the line.
That makes sense. Can we look at some specific examples from Chapter 2 just to see how this plays out in concrete terms, like for race?
Sure. Section 7 on race is quite specific. It prohibits things like spreading propaganda saying one race is superior or inferior, promoting racial exclusivity in associations, giving inferior services based on race, or denying access to contracts.
And for gender, Section 8, it seems to tackle some really deep-seated issues.
It really does. It explicitly prohibits gender-based violence, which is massive. Also things like female genital mutilation, the practice of stopping women inheriting family property, policies that unfairly block women's access to finance or land rights.
And it even mentions the systemic inequality that comes from the sexual division of labor. That seems quite progressive.
It is. It recognizes that societal roles assigned by gender can themselves be a form of unfair discrimination. Then you have Section 9 on disability. The focus there is very practical.
How so?
It prohibits denying or removing necessary support, like ramps or assistive devices. But more than that, it puts a positive duty on people and institutions to take steps to reasonably accommodate the needs of people with disabilities. It's about actively removing barriers.
So it's not just don't discriminate, it's actively enable participation.
Precisely. And the Act also goes after specific harmful behaviors like harassment and hate speech.
Okay, let's define those. Harassment first.
Harassment, under Section 11, is defined as unwanted conduct related to the prohibited grounds or specifically sex, gender, or sexual orientation, which is persistent or serious enough to be demeaning, humiliating, or creates a hostile or intimidating environment.
Persistent or serious. So a single really bad incident could count.
Potentially, yes. Then there's hate speech in Section 10. This is always a tricky one.
Yeah, balancing free speech. How does PEPUDA define it?
It says no one can publish, propagate, or advocate words based on any prohibited ground, where those words could reasonably be seen as showing a clear intent to be hurtful, incite harm, and promote or propagate hatred.
Hurtful, incite harm, and promote hatred. It's quite a high bar.
It is. And importantly, the Act specifically carves out exceptions. It says the hate speech rules don't apply to genuine engagement in art, academic inquiry, scientific research, or fair and accurate reporting in the public interest, as long as it doesn't advocate hatred based on race, ethnicity, or religion that constitutes incitement to cause harm.
So there's a defense for, say, journalists or artists or academics, provided they meet that standard.
Correct. It acknowledges the need for open discourse, but draws a line when it crosses into promoting hatred and inciting harm. It's a line courts are constantly interpreting.
Okay, we've covered what's banned. Now the crucial part. Enforcement. If you believe you've been unfairly discriminated against, what happens? Where do you go?
You go to the equality courts. These aren't entirely separate courts. High courts and specially designated magistrates' courts act as equality courts.
And who can actually bring a case? Is it just the person directly affected?
No, and this is really important. Section 20 allows a very broad range of people to initiate proceedings. Obviously, someone acting in their own interest, but also someone acting on behalf of others who can't act themselves, someone acting as a member of or in the interest of a group or class of persons.
So class actions are possible?
Yes. Also, anyone acting in the public interest. And key constitutional bodies like the South African Human Rights Commission or the Commission on Gender Equality can also bring cases.
That's incredibly wide access. Does it lead to a flood of cases?
It certainly opens the door wide, which is the point to make justice accessible. But you still have to make your case. And that leads us to probably the most talked about procedural aspect, the burden of proof shift in Section 13.
Right. This is a big one for law students. And anyone facing a case, how does it work?
Okay, so normally in civil cases, the person bringing the claim has to prove their entire case. Under PEPUDA, if the complainant, the person alleging discrimination, makes out what's called a prima facie case.
Meaning, like, providing enough initial evidence to suggest discrimination might have happened?
Exactly. If they meet that initial threshold, the burden, the responsibility completely shifts. The respondent, the person accused of discrimination, then has to prove one of two things. Either that the discrimination did not happen as alleged, or that the conduct was not unfair.
That's a huge shift. So how does a court decide if discrimination was fair? That sounds almost contradictory.
It sounds contradictory, but Section 14 provides a framework. Firstly, it clarifies that taking positive measures, like affirmative action, designed to help groups previously disadvantaged by unfair discrimination is not considered unfair.
Okay, so corrective measures are explicitly allowed.
Yes. For other cases, when deciding if discrimination was unfair, the court has to look at the whole picture, the context, the actual impact on the complainant, especially on their dignity, whether they're part of a group that suffers from patterns of disadvantage.
So systemic issues again.
Right. The position of the complainant in society matters. The court also looks at the nature and extent of the discrimination, whether it impairs dignity, and importantly, whether the discrimination achieves a legitimate purpose, and if there were less restrictive ways to achieve that purpose.
It's a multi-factor test then. But you mentioned earlier that this fairness test doesn't apply everywhere.
Correct. Section 15 is clear. The determination of fairness under Section 14 does not apply to hate speech or harassment. Those are considered inherently unfair if the definition is met. You can't justify them by saying they serve some other purpose.
Got it. Okay, let's talk remedies. If the court finds unfair discrimination, what can it actually order? Section 21 covers this, and it seems to go way beyond just money.
Absolutely. Financial compensation for actual damages or for injury to feelings and impairment of dignity, pain, and suffering is definitely possible. But the court's powers are much broader and more creative, really focused on fixing the problem.
Like what?
Well, they can issue interim orders or make declaratory orders saying certain conduct is unfair discrimination. Right. They can order the respondent to stop the discriminatory practice. They can order specific steps to be taken to end the discrimination, like providing reasonable accommodation.
And the apology one always stands out.
Yes, ordering an unconditional apology, that might sound symbolic, but it can be incredibly powerful for restoring dignity.
What about the more systemic remedies? You mentioned audits.
Right. This is where it gets really interesting. The court can order the respondent to undergo an audit of their policies or practices by an independent body to identify and fix discriminatory elements. Think about a company having its hiring practices audited.
That forces internal change.
Exactly. And the court can even recommend to a relevant body, like a licensing authority, that the respondent's license be suspended or revoked. That's a serious deterrent. It's about addressing the root cause, not just the individual incident.
This really paints a picture of the act as having teeth, not just ideals, which brings us to the final part. This isn't just about stopping bad things, right? There's a proactive side, too.
Definitely. Chapter 5 is all about the promotion of equality. It places a positive duty on the state. Government departments have to develop awareness campaigns, implement programs, review their own laws and policies to weed out discrimination. Ministers actually have to develop and implement specific equality plans for their departments.
And does that duty extend beyond the government?
Yes, it does. Anyone contracting with the state or exercising a public power or function also has a responsibility to promote equality. They might be required to prepare equality plans and report on their progress. It tries to embed equality promotion throughout society.
To help people understand the practical reach, the Act even includes a schedule, an illustrative list of potentially unfair practices. What kind of things are listed there?
It gives examples across different sectors. In labor, for instance, it mentions perpetuating big income gaps that stem from past discrimination or not following the equal pay for equal work principle.
What about something like housing?
For housing, it specifically calls out redlining, refusing loans or insurance in certain areas based on race or social status. It also mentions unfairly refusing accommodation to someone based on their source of income, like if they rely on social grants.
That health.
Examples include unfairly denying insurance based on HIV/AIDS status or refusing reasonable health services to older people. It really tries to show how discrimination can manifest in everyday life sectors.
And all this is supposed to be continuously monitored. There's a committee?
Yes, the Equality Review Committee, set up under Chapter 7. It's made up of high-level people, a senior judge, the heads of the Human Rights Commission, and Gender Commission, experts. Their job is to keep an eye on how the act is working, advise the minister, and recommend changes needed to keep it effective.
Which ensures the law doesn't just sit on the shelf, but adapts.
Hopefully, yes.
Yeah.
It recognizes that the fight for equality is ongoing and the tools need to stay sharp.
Okay, that brings us nicely to the final thought we wanted to leave you, the listener, with. Something to mull over.
Right. So the Act itself has this interesting Section 34, a directive principle. It highlights certain grounds, HIV/AIDS status, nationality, socioeconomic status, and family responsibility status, as needing special consideration by the Equality Review Committee.
Why those specific grounds?
Because the Act recognized early on their strong link to systemic disadvantage and discrimination, even if they weren't all included in the main list of prohibited grounds initially. The committee was tasked with investigating whether they should be formally added.
And socioeconomic status is defined quite broadly, basically relates to poverty, unemployment, lack of education.
Exactly. So here's the provocative thought. The Act defines equality itself in Section 1, not just as formal equality before the law, but to include equality in terms of outcomes.
Equality of outcomes, not just opportunity.
Right. So if the law is seriously considering socioeconomic status, essentially, being poor or lacking qualifications as a potential ground for prohibited discrimination, what does that imply about its ultimate aim? Is it pushing beyond just non-discrimination towards actually trying to achieve more equal results, more equal life chances, regardless of the economic circumstances you were born into? That potential shift towards substantive, outcome-based equality is arguably the biggest ongoing challenge and debate surrounding this act.
A really profound question about the future shape of social justice. That was our deep dive into PEPUDA. Thanks for walking us through such a complex and vital piece of legislation.
My pleasure. It's a crucial one to understand.
Absolutely. We'll catch you next time for another deep dive.